All right, so thank you very much everyone for joining us for today's masterclass, where we'll be having Lauren Handel talking about food labeling and how to not get sued for your labels. Yeah, I love it. And so for those of you who don't know us, don't know me, I'm handling basically managing our community at Be Driven, among other things. And at Be Driven, we're specializing in working with emerging clients, emerging brands, and helping them with sales, distribution, with direction management, accounting, and also have a network of experts such as Lauren, who are helping our clients to kind of navigate the industry. And so before we start, we'll go for 60 minutes. If you have any questions, you can feel free to add them to the chat box. And we'll get to them after, or you can also wait for after the presentation to ask directly Lauren. And okay, Lauren, I think stage is yours.
Okay, thanks. So just quickly about me, I have a very small practice law firm that's focused on food businesses called Handel Food Law. I am actually based in Northwest Arkansas now as of July of this year, but I'm originally from New Jersey and admitted to practice also in New York and New Jersey. And all of my clients are food businesses. A lot of them are very early stage startups, or they are well established but still small businesses that are still controlled by their founders for the most part. And a lot of what I do is reviewing people's labels and their marketing materials to help them comply with regulations and to minimize the risk that they get targeted in a class action lawsuit, which is what we're going to be talking about today. And so let me just share my screen. Let's see, it worked before, so hopefully it works again. Okay, can everybody see that?
Yep.
Okay, so we're talking about litigation risks. If you have not heard, there is a lot of litigation around food labeling. Most of this is class action litigation. And so it is actually right now what I consider to be the biggest driver of regulatory compliance for the food industry. But I want to give you some background on the regulatory front first, just really quickly, an overview of who regulates food labeling. So the Food and Drug Administration, FDA, has overall responsibility for the regulation of food products, including their labeling, but specific primary jurisdiction is delegated to different agencies for certain kinds of products. So when it comes to meat, poultry, egg, and by strange quirk of food law, catfish products, the US Department of Agriculture is primarily responsible for those and for their labeling. When we talk about alcoholic beverages and another quirk of food law, non-alcoholic beer, the TTB is responsible and has its own set of regulations when it comes to labeling. The Federal Trade Commission at the federal level is responsible for consumer protection and advertising, and to some extent, online especially, advertising also is considered labeling. So there's some overlap of FTC and FDA or USDA jurisdiction, and FTC also has guidelines around claims like made in the USA. I should have mentioned also, USDA also is responsible not only for meat and poultry products, but also for all products when it comes to organic labeling, and a fairly new disclosure requirement for bioengineered foods, or GMOs as they're more commonly known. Then at the state level, there are state counterpart agencies to all of the above that have their own regulations, mostly which mirror or enforce federal regulations, but then there are also other kinds of state consumer protection laws. And then I include on here courts, which you might not think of as a regulatory entity, but through litigation, companies effectively can be regulated in that litigation often seeks an order from the court that requires a party to change their label or imposes damages and therefore incentivizes a party to change their label or their advertising. And the kinds of litigation can be consumer class actions, or it also can be litigation by competitors. So a competitor might sue another company on the theory that their false advertising or misleading labeling is a form of unfair competition. So on the regulatory side, in food law, both at the federal and state level, there's something called misbranding. So this is the idea that there is something wrong with your label, and it can be that it is false or misleading, that it's misleading as to the fill of the container, meaning consumers will think there's more of the product in it than there actually is, or it can be like a technical form of misbranding. So there are extensive rules or regulations around both things that you're required to put on your label, or certain conditions for making certain kinds of claims. And the violation of those rules make the product misbranded. And it is illegal to sell misbranded food products. So I mentioned my talk mostly about consumer class actions, as this is the most active kind of litigation. Competitor lawsuits also are possible. There aren't nearly as many of those as there are consumer class actions. And just to give you some background on the nature of this kind of proceeding. So these are claims that arise under state consumer protection laws. Also, there can be common law claims. And the plaintiffs in these cases need to prove that the label, or sometimes it's also the advertising, is likely to deceive reasonable consumers. So there's something about it that's false or misleading based on the way a reasonable consumer would interpret that claim or the label or the advertising. That this misrepresentation is material to the consumers, meaning it affects their purchasing decision. They either would not purchase the product if they knew the truth about it, or they wouldn't have paid as much. And that is the reason for the damages. So it's also required to show that the consumers were harmed in some way, in that they either bought a product they otherwise would not have bought, or they paid more for it than it was actually worth. And the idea of a class action is you will have one, or it could be a few named plaintiffs, individual people who are seeking to represent not only themselves and their individual claims, but an entire class of people who have purchased this product. And that could be within a particular state or a few states, or it could be nationwide. So the realities that are important to understand about civil litigation is sort of how this game is played, is, as I often refer to it, is it's really easy in our system to file a lawsuit. And the standard to have that case survive past a motion to dismiss, which would be the defendant's first opportunity to try to win the case, would be to get it dismissed early on. It's pretty easy for plaintiffs under the standards that exist to get past that stage. And once you get past stage, it gets much more expensive to litigate. So you have to go through discovery, there's motion practice, the whole process can take years to get to trial. In a class action, there is a class certification stage. So there's a lot of work that goes into it. There's a lot of legal fees, there can be expert fees, and this is all expensive. And on the defense side, it is extremely rare that you would ever recover. So even if you have a very strong case and you win, it is very unlikely that you would recover back your attorney's fees or your costs. On the plaintiff side, if the plaintiffs win under the state consumer protection laws, there's often provision under the statute for them to recover attorney's fees. So there's a different equation there for plaintiffs that incentivizes plaintiffs to bring cases and incentivizes defendants to settle. And so the vast majority of the cases do settle. That's true of any kind of litigation. In this litigation around food labeling, what I see is there are a lot of cases that get filed. For the last 10 years or so, we're talking about somewhere between maybe 200 and 300 cases a year are getting filed. And there are, I don't know how many more, but a lot more cases that never get filed, that start with a demand letter. Under some state laws, it's required for the plaintiffs to send a letter first before filing suit. And the letter will say, I have a client who's going to sue you for your misleading labeling, and change it now, or we're going to file this lawsuit, right? And sometimes that includes a draft of the complaint. But at that stage, it's still a confidential process. It's not, at least it's not been made public. It hasn't been filed in court. And so many cases get settled at that stage before they even get to court, especially when we're talking about smaller companies, where it's just not even going to be worth going through the expense of litigation, because the dollar amount that's potentially recoverable isn't really high enough to justify the expense of litigation. There's a greater risk, if you are a food business, that a non-compliant label, or a label that has some sort of problem, will be the subject of litigation than the target of a regulatory enforcement action. So the reality is that the regulators can only do so much. They don't have the bandwidth to be enforcing all of the rules, especially when it comes to FDA. USDA is different significantly in that USDA has to review and pre-approve labels, whereas FDA does not. But for an FDA regulated product, it is not likely that you would hear from FDA if you had a violation on your label, unless it was at a really severe level, right? So FDA does have a enforcement priority of going after companies who make what are called drug claims, right? So if you're positioning a product as being useful to treat or mitigate disease, FDA will come after you. But otherwise, for the other issues, they just don't have the capacity. Whereas the plaintiffs' lawyers are motivated and aggressively working in this area. So that's the bigger risk. Your compliance with regulations may be a defense, but it's not necessarily a dispositive defense. So for some kinds of issues, the fact that your label complies with FDA regulations is enough to establish that a state law claim cannot move forward. It is preempted by federal law. But there are other cases where the courts have said federal food labeling regulations and state consumer protection law can work together. And you can have a label that fully complies with FDA regulations and still is deceptive to consumers, and therefore could be the basis of a claim. It's not a defense that competitors make the same label claims, right? So I get this a lot from my clients, that they come to me with a label or with something they want to say about their product, and they very quickly tell me about their competitors and other products that they see on the market that have the same sort of claim on them. And my response to that is usually, if you look at how fast people are driving on the road, does that tell you what the speed limit is, right? That there is only so much enforcement. And the fact that other people have chosen to take a risk or have not been hit with an enforcement action or a lawsuit yet doesn't mean that it's safe for you to make the same sort of claim or that you would have a defense. And then finally, no brand is too small to get sued for this type of issue. And I've actually, in my practice, because my clients are small, I see a certain subset of the plaintiff's bar that seems to intentionally target very small companies, knowing that they don't have the funds to defend these lawsuits, and therefore will be more motivated to settle early. And that will help those plaintiffs' firms to fund their work while they're litigating against the big companies who do fight back and have the resources to fight back. And so when you see the cases that get reported in the trade press, those tend to be against big companies, and it might give people the idea that, oh, the plaintiffs' lawyers only go after the deep pockets. That's not true. But the cases that end up in court tend to be the ones against bigger companies because they don't settle as quickly and they fight back. And so they get to to stages where there are decisions that get published and there gets to be more press about it. So I'm going to go through some examples from real cases in the last few years, most of them within the last year, of the kinds of targets that are what I would consider higher risk, that come up time and time again. There are definitely patterns in this type of litigation where certain plaintiffs' lawyers they'll find a kind of claim that they want to target, and then they'll go out and look for all kinds of examples of other products that make the same kind of claim. So they get to reuse pleadings and just kind of churn through a lot of cases that involve the same kind of issue. And then there are issues also that seem to stick, that courts have let get past motions to dismiss, so that becomes appealing for other plaintiffs' lawyers to seize on the same type of issue. So there definitely are some patterns, but I want, before we get into those examples, I don't want you to think that, oh, if I stay away from these areas, I'm safe, because that's not true. You really have to think about what issues, what representations are you making about your product? And that can be express language that you use in a claim. It can also be something that you are implying, either with language that's less direct, with imagery, with the all of the messaging put together. What are those representations that you're making about the product that may be not totally true or potentially misleading? If those are things that would be material to a consumer's purchasing decision, that is something that could get you sued. And I also just want to distinguish between factual representation. So a claim is something that can be proven true or false. It is a representation of fact. There is a safer territory for marketing, which is statements of opinion, statements about subjective, it's delicious, it makes you feel good, those kinds of things. It's the best. There's things that are called puffery, statements that are kind of so exaggerated that nobody could actually believe it's meant to be a factual statement. Those are not claims that can subject you to liability. But if it's a representation of fact, something that could be proven true or false, and it's not true, or if it's misleading, that could subject you to liability. So here are the examples of targets that I've seen. And excuse me while I try to prevent myself from coughing. The claim natural or all natural, this has been around for at least 10 years now and remains an active area of litigation. And it's got similar, different versions of natural as well. A category called health washing, or basically representing that a product is healthy. Nutrient content claims, which is an area that FDA regulates with specific rules. Representations about the source of a characterizing flavor of a product or key ingredients in it. Functional benefits of a product. Animal welfare or ethical sourcing kinds of claims for foods that are derived from animals. Greenwashing or like environmentally friendly kinds of claims. A fairly new area are products that are found to have trace contaminants in them. An emerging one is PFAS chemicals, but it could be other kinds of contaminants as well. Slack fill is where consumers might be misled about how much of a product is inside a container. And then Proposition 65, I have to include because we're talking about litigation risks. It is not the focus. My focus is more on the deceptive marketing, false advertising kind of claim. But Proposition 65, which is a California law, is a huge litigation risk for anyone in the food industry. So natural. So first you should know that there is no regulation defining the term natural. FDA and USDA both have informal policies on this issue, which is basically they're not going to take exception to use of the claim natural. Either way, FDA words it is that there's nothing artificial or synthetic in the product and no coloring, and that could be coloring even from natural sources that consumers would not normally expect. what consumers would normally expect is completely up for debate, is obviously vague, and it's also not something that FDA has enforced really at all in the last 10 or plus years. And while FDA a few years ago put out a notice asking for comments on whether it should define natural and how it should define it, and I think it was in 2018, said that they would be doing this, that they would be saying something more about it. Nothing has happened since then. On the USDA side, so again, meat and poultry, egg products, catfish products, the definition is no artificial flavors, coloring ingredients, chemical preservatives, or any other artificial or synthetic ingredient, and the product is not more than minimally processed, which adds a different concept that's not in the FDA definition. But again, this is informal, and so it's not really a standard that will bind plaintiffs in consumer deception cases. So here's some examples of actual cases. So there's a case pending right now that is about Snapple juice drinks that have all natural very prominently on the label. And here the allegation is it's not all natural because it also contains citric acid, which is usually from synthetic sources, although not always. And it also contains fruit and vegetable juices as a coloring, which is against the FDA policy on natural. But other kinds of cases that have challenged representations that a product is natural have been where the product is made with GMOs, like GMO vegetable oils, other kinds of synthetic or artificial or very highly processed ingredients. Like one of the first cases actually was against Snapple for high fructose corn syrup in iced tea, I think, where that was labeled as all natural. And the plaintiff said, you've got high fructose corn syrup in it, which is about as processed as you can get. That's not all natural. Or there have been cases where products have been tested and found to contain chemical residues like pesticide residues or contaminants like PFAS, which I'll talk about a little bit more later. Other kinds of contaminants that were not intentionally added to the product, but are present in it. And it's alleged, therefore, that consumers are deceived when they think that they're buying something that's entirely natural. Representations that a product has no artificial flavors or preservatives. So you might think of this as a different version of natural, but it is somewhat different. In most of these cases, the product at issue, like this Crystal Light drink mix, have a multifunction acid in it: malic acid, citric acid, sorbic acid. These are things that may not have been put in because of their effect on flavor or preservation. They might be in there as an acidity regulator or to enhance flavor, but not what we would normally think of as a flavor is, in this case, strawberry, kiwi. It says under it, natural flavor with other natural flavor, right? So that's required FDA language that says there is a flavoring, an ingredient that imparts, in this case, strawberry and kiwi flavor. That's what we would think of as the flavoring. And so when this was labeled no artificial flavors, perhaps the manufacturer was not thinking about, well, there's also malic acid. I'm not sure which acid it is in this product, but malic acid or citric acid that does actually have an effect on flavor, or maybe it has an effect on shelf life. And therefore the theory of the case is it's false that there are no artificial flavors or preservatives because you have these ingredients that actually do have an effect on flavor or preservation. And there have been a lot of these kinds of cases. Health washing. So this is a broad category of products. They tend to be products that have significant amounts of added sugars. They tend to be breakfast products. So breakfast cereals have been a target of this kind of litigation. What's interesting is there's not usually one claim on the label that's being challenged, but it's really the overall messaging. So in these cases, Belvita biscuits and the Cliff Kids Z bars, you've got representations that the product is nutritious or it's nourishing kids in motion. You've got nutrient content claims talking about how much whole grains are in the products, vitamins and minerals. It's sort of overall positioning the product as good for you. And the allegation is that's deceptive. It's making the product seem more healthy than it really is because added sugars are bad and these products have a lot of added sugar. Nutrient content claims. So there are very specific regulations, both in FDA and USDA regulations, about claims that are made outside of the nutrition facts panel about the level or amount of nutrients in that product. So on the front of the pack, here's an example, high protein lentils. There are conditions that you have to meet based on percent daily value to make a claim like that. And then sometimes there are additional disclosures that have to be made. And the failure to comply with those rules has gotten people sued. So in this case, the allegation is it says high protein lentils on the front, but it fails to have the required percent daily value for protein in the nutrition facts panel, which if there were no protein content claim would not be required. But once you make a claim about protein outside the nutrition facts panel, you then also have to include percent daily value. Apparently that was missing in this case, and that's why this company is getting sued. Sugar-free, no added sugar kinds of claims. Also, there have been a lot of lawsuits and threatened lawsuits around labels that have those kinds of claims without the disclosure that's required under FDA rules, which is if the product doesn't count as a low-calorie food, which most do not, you're required to have that additional language. And so this is an example of plaintiffs are able to use consumer protection law to basically enforce FDA rules. If they were trying to impose a standard that was different than FDA's regulations, the claim would be preempted. But if the claim is consistent with what FDA requires and the label has just failed to meet FDA's regulations, then that can also be the basis of a consumer protection claim. Functional benefits. So this is an example I wanted to include because there was a Ninth Circuit decision yesterday, I think, about this case, and it's an example of how long litigation can take. I think this case was filed initially a few years ago, and it was dismissed by the trial court and got up to the Ninth Circuit Court of Appeals, which has decided that the trial court was wrong to dismiss it. The case can actually go forward. And here the product is represented, even the product name, glucose control. It says that it helps manage blood sugar and is designed for people with diabetes. And the plaintiffs say this led them to believe that it would improve their blood sugar, that they are diabetic or pre-diabetic, and that whatever blood sugar they have now, if they drink this, it will improve their blood sugar. And the defendant says, no, that's not what it means. It means that if you drink this, you won't have as much of a spike in blood sugar than if you were to drink other kinds of nutrition shakes that don't have as much protein in them. And so they have a disagreement about what this means. And the Ninth Circuit said, okay, fine. But the plaintiffs have said enough that they should be able to put on their case, and then ultimately can be decided by the jury whose interpretation is the one that consumers are likely to take away from this labeling, and is it misleading? But there can be other kinds of any sort of representation that a product has a functional benefit. If that cannot be fully substantiated in accordance with whatever reasonable interpretation consumer might make of that claim, that could be the basis of a lawsuit. Characterizing flavors and key ingredients. So there have been hundreds of lawsuits, mostly brought by one plaintiff's firm, about products that have representations about their flavor or a particular ingredient, highlighting a particular ingredient where maybe there is only a little bit of that ingredient, or the flavor is coming mostly from a different source, such as a flavoring additive. And so here's some examples of that. The fruit cocktail in 100% juice, the allegation is that that's misleading because it's not only juice, but it's juice and there's citric acid in it, I think. There's water in it. And so therefore that's misleading. Habanero barbecue almonds, there actually is habanero chili in it, but the allegation is it's not getting most of its habanero flavor from that, but from other artificial sources. This one I wanted to include because it really drives home the point about no company is too small. So I don't actually know how big this company is, but of this product, Noni's lemon biscotti, their total sales in New York, and this is a New York class action, are less than $100,000. But the potential damages here are more than $9 million because New York has a statute that makes available statutory damages of $550 per instance. And the court says that means per box of this product. And so even before accounting for attorney's fees, which might also be recovered, the potential damages here are more than $9 million for a product that had less than $100,000 in sales. But the allegation here is the product says it's limon biscotti made with lemon zest oil. It also says things like real ingredients, no compromises. But at least part of the lemon flavor is coming from a natural flavoring and not only from lemon zest oil. And so the plaintiffs allege that's deceptive. Animal welfare or ethical sourcing kinds of claims. So again, this is an area where there are no regulations defining terms that we see in the marketplace a lot, like humane or pasture raised, free range, antibiotic free, sustainably sourced, right? They're not defined terms, ethically raised. There are certifications, in this case with Nellie's free range eggs. The allegation is that free range is deceptive because that, and also together with a lot of the other representations that are made on the packaging and also in the advertising of these products, suggests that the hens are outdoors a significant amount of time and having happy lives. And it's alleged that they're actually living in crowded chicken houses and not out on pasture like in the imagery might show on this egg carton. The defense says, well, when we use free range, we mean this meets the certified humane standard for free range. And the plaintiffs say, well, that doesn't matter because consumers will think it means much more than that, where that certification may only require access to the outdoors. Consumers are going to expect that the hens are actually outdoors, roaming freely, and that's not the case. So it's interesting. It's an example, and there are others where a certification is not necessarily protection against a lawsuit, especially if the representations go beyond just being directly linked to that certification. And I know that this is a case involving eggs because eggs in a shell are within FDA jurisdiction. USDA, while there have been some cases challenging claims like this on meat and poultry products, those are much more difficult to bring because USDA, again, reviews and pre-approves labels when they make claims like this. And therefore, there is a much stronger defense of preemption for a USDA regulated product than an FDA regulated product. So most of the cases that you'll see will involve products that are within FDA jurisdiction, like shell eggs, or in this case also seafood, which is within, except for catfish, FDA jurisdiction. So greenwashing as a category is kind of environmental friendly, environmental benefit sort of claims, sustainability claims. The FTC, Federal Trade Commission's green guides are guidelines. They are in the Code of Federal Regulations, but they are guidelines about various kinds of environmental benefit claims. And they have some concepts in there that get cited a lot by plaintiffs, lawyers, in litigation. Especially there is a warning against making really broad environmental benefit claims, right? So it is risky to say that a product is sustainable without being much more specific about what you mean. Sustainable in what way? Because there are many possible interpretations of that term. And when considering all of those interpretations, they may not all be true, or you may not be able to substantiate all of them. So here's a couple examples of products with sustainable claims. The Bumblebee seafood products have the MSC, Marine Stewardship Council, certified sustainable seafood certification. And that certification itself, the representation in it is being challenged in this case. The allegation that the products are not actually sustainable, that the fishing practices are harming to seafood or to fish populations and marine life, and that they actually promote forced labor. Similarly with the chocolate chips, that they say they're sustainably sourced, and Nestle has its cocoa plan and certification, and the allegation is that its chocolate products are not sustainably sourced because there is also slave labor involved in their supply chain, and that it harms, that it causes deforestation. So those are examples both where they're really broad interpretations of what sustainable means, and where it can be really challenging for the defendants to be able to substantiate all of those different interpretations. So PFAS chemicals, this is an emerging area of regulation and liability in a lot of different situations, not just in food, but in all different kinds of products where PFAS chemicals can be found, like textiles and cosmetics. So these are chemicals that you might have heard mostly of nonstick coatings in pans, right? So they're chemicals that can be used for a variety of industrial uses because of their non-stick properties and moisture resistance properties. So they've been used in food packaging, and especially in fast food, like wrappers, right? To keep the wrapping from disintegrating when it gets in contact with moisture. These chemicals have been used in coatings, and they're called forever chemicals because they persist in the environment, they persist in the human body. There is debate about, and there's lots of, I forget, like hundreds of PFAS chemicals, and some have been proven to be unsafe for human consumption, but that's not necessarily true of all of them. But they're ubiquitous in the environment, and there's been issues with them in groundwater. And now apparently plaintiffs' lawyers have tested products, Bolthouse Farms, smoothie drinks, and other products, and are finding PFAS chemicals in these products. Not necessarily at levels where they are unsafe, and that's not even the allegation, but that it's deceptive to market a product as being feel good and nutritious and sort of generally healthy or good for the environment when it contains these contaminants. And again, it's important that these are contaminants. They're not intentionally added. And I'm not sure how they get into a juice product, but apparently they have. And so this is an emerging area of risk because my understanding is these chemicals are kind of everywhere, and it would be very difficult to ensure that there are none in any food product. Heavy metals, likewise, are another kind of contaminant where there's starting to be more litigation. So there was an article by Consumer Reports that they went out and tested a bunch of chocolate and found elevated levels of lead and cadmium, which is a known issue in cacao, as it is with a lot of natural products, that in the environment, these plants will take up heavy metals that exist in the soil, and it can get into the food. And this is an issue for Proposition 65 warnings, but now it's also becoming an issue in that chocolate products have been the target of lawsuits where the allegation here isn't that there's a misrepresentation in terms of an affirmative statement, but an omission, that the failure to put a warning on a product, even if it wasn't required, such as by Prop 65, required by a statute or regulation, is deceptive to consumers because that's material information that they would like to have when they decide what products they buy and consume. Slack fill. So this is a picture I took from a complaint in a case where the idea of slack fill is consumers can't see inside the container, and then they are disappointed when they see how much of the product is actually in there. And we all know products are labeled by weight usually, and you see more and more products that have a fill line on the outside to try to deal with this issue. But the theory is it is deceptive because consumers will expect more. They don't know necessarily just based on the weight how much they're getting. But there are defenses to a case like this if the consumers can see the level of fill. So either that's because it's a transparent container, it has a window, or it has a line marking that fill level, that the contents will normally settle, which is probably the case with this product. Or the empty space is functional, and there is an amount that's needed as a cushion. So like for chips, that there needs to be air in the package to keep them from all just crumbling. Another kind of twist on this is cases where the product, in this case, Folgers coffee, states how many cups of coffee it makes, and the plaintiffs go and make the coffee and find they don't get 240 cups. They got something less than that. There have been similar cases involving baby formula, but the same idea is they didn't get as much as they expected based on the representation about the number of servings that could be made per container. So Proposition 65, there's an example of a warning. If you are in California, you will see these all over the place. The reason why it's a big litigation risk, and it's an increasing litigation risk. I saw statistics recently that in the last couple of years, the number of cases, Prop 65 cases for food and supplement products, so mostly food products, has like doubled. It's just gone way up. And that is because the law has a bounty hunter provision. So it allows private individuals to bring a lawsuit and to bring a class action lawsuit to enforce the requirement that products be labeled with a warning if they contain chemicals above what's called a safe harbor level. So above a certain level, a warning has to be provided if it can expose consumers in California to any one of a number of chemicals on this long list of chemicals that the state has found to be cancer risks or risks of reproductive harm. So for food, beverages, supplements, the biggest issues are heavy metals, because again, they can naturally occur in agricultural products or in seafood. Seafood can take up heavy metals like mercury from the water. So those kinds of products are a target. Acrylamide has been a big issue in baked and fried foods. For now, there is a court ruling that those kinds of lawsuits cannot be brought with respect to acrylamide, but we will have to see. That's a preliminary injunction, and we will have to see what happens with that lawsuit. That's not necessarily going to be the case forever. An important thing to know if you are a small business when it comes to Prop 65 is a lot of people think that they're small. They are aware that there's an exemption for companies that have fewer than 10 employees. But what you need to know is that it's true. Technically, you're not required to comply if you have fewer than 10 employees. But if you do business with larger companies, if you sell to a large retailer that resells your product, the onboarding paperwork that you sign when you start to supply that retailer most certainly puts all of the liability on you if your product does not comply with Prop 65. So there's provisions in there that you're required to defend and indemnify that retailer or the distributor. And so practically, it doesn't matter that you have a technical exemption. You will just, by doing business, unless your business is strictly direct to consumer, you will practically have to comply with Prop 65. So how do you minimize this risk?
Lauren,
so, step one.
Sorry, I'll just pause you. We have 10 more minutes. I want to be mindful of your time, and we have a couple of questions.
Okay.
So how many more slides do you?
We're almost done, so
Okay.
that'll be great.
Okay.
All right. Step one: comply with the regulations, but that's not enough because, as I mentioned before, you can be compliant and still allegedly misleading to consumers and therefore have a claim against you. Consider what messages consumers will take away from the overall labeling and advertising. So I often get clients come to me and they want my feedback on a particular claim, like a sentence. And I can never really give meaningful advice on that sentence because I need to see the overall messaging. Like, this sentence might be fine in certain contexts, but then depending on what else you say about the product, it might not be okay. And also consider imagery. Then you have to consider, are all of the reasonable interpretations of this messaging truthful, not misleading, and substantiated? So even if you have a particular intent of what you think the message means, are there other interpretations that consumers could take away, and are those also true and not misleading? And can you substantiate them? Do you have evidence to back them up? When to get legal advice? So ideally, early. Clients often come to me with a label a week before they want to get it printed and say, can you just take a quick look at this? It's probably fine. And we just want to make sure that it's okay from a legal perspective before we get it printed. And I often find significant problems with those labels that get back to like core fundamental issues that should have been thought about when the product was being developed and when the marketing strategy was being developed, like a claim you absolutely cannot make or can't support. Before launching new labels and marketing materials certainly would be a good time. When you're making changes to the product, so this is not a one and done. You go through a great legal review, get blessing on your label, but then you make a significant change to the product that might affect whether the label remains compliant, or you do a brand refresh and change some things about it, even just the imagery on the package, like that requires a fresh look. And then also things, if I do a label review, my advice is good right now, but things change over time. The rules and regulations change over time. The litigation risks change over time. So even if you don't make changes to the product or the label, it's a good idea to periodically get another look and see if there's any new issues that might require some changes to be made. Then how do you guide your marketing team? So I encourage my clients to create guidelines with input from legal counsel on what is acceptable messaging and what messaging is not acceptable. So based on what we can substantiate and how we want to position the product, what kinds of things are safe territory and what do you need to stay away from? And then use that to train the people who will develop your marketing materials and your labels. And also train them to recognize at least what territory is regulated or risky, so that they don't necessarily need to be experts on the regulations or the litigation, but to know that a red flag goes off, we should get legal advice on this. And then have an idea of your tolerance for risk and the balance that's appropriate for your company, of the marketing advantage that you're going to get from certain kinds of messaging against the litigation risk that you might face. And you can't do that unless you really know and appreciate what that risk would be. But I think often people think they have to say a certain thing about their product because other people are doing it, or they think it's really going to have a big advantage in the marketplace, when I'm not really sure that they have, you know, consumer survey evidence to back that up. But there might be a really high risk, which would say stay away from that messaging. It might not be worth that. And that's it. Here's my contact information. I'd be happy to answer further questions. I answer questions now as much as we can. But if people have other questions and want to contact me after, that is absolutely fine. You can reach me by email or phone or on LinkedIn. So should I go to the chat?
Awesome. Thank you, Lauren, so much. It was so much great information.
Thanks.
Yeah. So, okay, I'll go through the questions. First from Miguel. So in your example, I think you were showing example of a product with some ingredients on it. So asking, instead of habanero, a good label wording should say habanero flavor. Like when do you?
Yeah, so there's actually a very detailed rule on this. And and first, just disclaimer, this isn't legal advice. I can't actually give you specific advice without knowing more about the product. But there is a specific regulation on how you describe characterizing flavors. And if a product is one where consumers would expect the actual ingredient to be in the product, and it's not getting all of the flavor from that actual food, but from a flavoring, it really should be labeled flavored under the regulation. But you will see people use flavor as a way of trying to convey that I'm not saying this has that ingredient, I'm saying it has the flavor of this ingredient, and that may or may not technically comply. I am seeing plaintiffs' lawyers get really expert on how to apply this regulation and are holding brands to a really strict standard of compliance. And I've dealt with some demand letters where it was just, you know, the whole allegation is this label is deceptive because it didn't say the required flavored with other natural flavor, which is also sometimes required depending on the type of flavoring additive that's used.
Got it. Yeah. So hard to understand what all the things are. Okay. So for Luke, before he left, so I saw a brand this week where it appeared that the product was filled to near the top of the container. We're talking about that. When I went to use it, the product discovered the middle of the product was hollowed from the way that it was filled. So could this be a cause for lawsuit? So you mentioned that yes, but then they can defend that has some functional purpose to it, right?
If it has a functional purpose, so I don't think I've ever seen a package like that. I'm wondering why it was designed that way. But so if there is actual a functional purpose to it, then that might be a defense. But it sounds like it also potentially could be a source of liability, right? That, I mean, at least Luke was surprised that he wasn't getting as much as he thought he was going to get.
Yeah, I saw it. It looked like completely filled, but then there was like a hole in the middle. Like, so this is disappointing. We're also seeing a lot of ADA lawsuits regarding websites. Do you work in this area too?
I do, in as much as I have helped some clients in negotiating settlements of lawsuits like this. So it's a very active area of litigation, especially in New York. But I am not an expert on the technical aspects of how you comply, right? So people really need to work with web developers who understand the compliance guidelines. But yes, it's another area where a lot of brands are getting hit with lawsuits.
Yeah, I've heard from some brands as well. From Miguel, a good image of the product needs to be precise of the product, or a legend saying image is for illustration purposes works well enough. Would you say that that's?
Yeah, so you'll see a lot of disclaimers that don't always make a lot of sense. So the basic rule is the imagery should be a fair representation of what's in the package. And if it's altered in some way, so often you'll see the product with some additional ingredients, and then the disclosure is serving suggestion, and that makes sense in that case, right? So the things that are shown in the picture aren't all in the box. Or it's enlarged to show detail, or people get cute with that and say enlarged to show deliciousness or things like that, right? But basically, if you're changing the image in a way so that it doesn't look exactly like the product, you should have some sort of disclosure. What that disclosure is depends on what change you made. And what I see is people just default to serving suggestion, which doesn't always make sense.
Okay. So another question from Miguel, how about an illustration that shows recommended use of prepare, which is the serving suggestion, right? When the soup sold is not even cooked. So
yeah, that's right. So that would be serving suggestion, right? So sometimes what I would think of as for illustration purposes would be if you're showing something totally different, like you're not trying to show the product itself, but you're trying to show ingredients in the product. And then you get into whether that's a representation about flavor and does it actually have those ingredients. So you have to be careful about that. But if you're showing the prepared product, then that's where you would do serving suggestion.
Okay, got it. Chris is asking, do outside states that are selling direct to consumers in the state of California have to follow all the California rules?
Yes.
That was clear.
Yes, it doesn't matter where the seller is. If they are selling to consumers, California law applies to the product that's being sold.
Okay, awesome. I think that's all for the questions, and we are 12:01. So thank you so much, Lauren. It was so great to have you here and so informative. Yeah.
You're welcome. Thank you for having me.
Awesome. And thank you guys. We'll see you at the next masterclass is next year. So keep an eye on your inbox when you receive invitation, and feel free to reach out to Lauren. We'll send a replay after and also contact on how you can reach out to her. Okay.
Great. Thank you. Happy holidays.
Happy holidays. Bye.